They're telling you the Supreme Court just ended the Second Amendment. They're also telling you it protected public safety once and for all. Both sides are wrong, and believing either one could destroy your future. Because buried inside this 8-1 Supreme Court decision is a truth almost nobody online is explaining correctly. A truth that doesn't just affect gun ownership, but what you can say, post, or even be accused of saying. And if you misunderstand it, the consequences aren't theoretical, they're personal, and they're permanent. Here's the scary part. This ruling didn't quietly change the law. It quietly changed how courts think. And once that switch flips, it doesn't flip back easily. Before we go any further, listen closely. If you own a firearm, plan to own one, or even talk about gun laws in the USA online, this video matters more than you think. Because this case isn't about criminals, it's about process. And process is where rights live or die. Now, you've probably seen the headlines screaming everywhere. Supreme Court rules 8-1 on guns. People ran with it. Creators panicked. Comment sections exploded. But almost nobody slowed down to ask the only question that matters. What did the court actually say? And what did it very deliberately avoid saying? Let me paint the picture. The case centers on one razor-sharp question. Can the federal government temporarily disarm someone after a judge has already determined that person is a real, credible threat to another human being's physical safety? Not accused, not rumored, not trending on social media. A court, evidence, a finding, a threat. And the Supreme Court answered, yes, temporarily. While that order exists, that's it. That's the ruling. But here's where the manipulation starts. The court did not say the Second Amendment is optional. They did not say allegations erase rights. They did not greenlight broad gun bans or open-ended disarmament. This decision is narrow by design. And that narrowness is everything. Because in gun laws in the USA, details are the battlefield. And here's the twist nobody warns you about. This case isn't just about restraining orders. It's about how Bruen is being interpreted. After Bruen, lower courts started playing a dangerous game. Some judges treated history like a museum exhibit. Unless the government could produce an exact gun law from the 1700s, they'd strike modern laws down. Perfect copy or nothing. The Supreme Court just shut that down. They said the Constitution isn't frozen in time, it's not a fossil, it's a framework. You don't need a historical twin, you need a historical analog. And that single word, analog, is where everything changes. Because once courts focus on why a law exists and how far it goes, the entire chessboard shifts. And that brings us to the part nobody sees coming. Because this same logic doesn't stop at guns. It spills into speech, into pressure, into who can silence whom, and how. And that's where part 2 gets uncomfortable. Here's where the story turns, and most people lose the plot. Because while everyone is fighting over the Second Amendment angle, the Supreme Court quietly reshaped the First Amendment battlefield at the exact same time. Different case, different facts, same danger if you don't connect the dots. Let me ask you something uncomfortable. What if the government never bans your speech, but scares everyone else into silencing you? That's not a hypothetical. That's the case. While the 8-1 gun ruling dealt with restraining orders, another Supreme Court moment focused on government pressure, the kind that never shows up in official law books. The kind that happens behind closed doors, through emails, phone calls, and suggestions. Here's the issue in plain English. Can government officials encourage private companies, like social media platforms, to suppress certain viewpoints, and then claim, hey, we didn't force them? For gun groups, gun educators, and anyone discussing gun laws in the USA, this question is existential. Because if speech disappears without a law, how do you challenge it? The court drew a sharp line. Pressure matters. Threats matter. Nice company you've got there. Energy matters. If the government uses its power to coerce or strong-arm private platforms into silencing lawful speech, that's not private moderation. That's state action in disguise, and it triggers the First Amendment. Why does this matter to you? Because combine this with the 8-to-1 Second Amendment decision, and you get a new reality. Courts care about process. Courts care about specific findings. Courts care about limits and duration. They're not asking, is this politically popular? They're asking, who decided, how, and for how long? That's good news and bad news. Good news because blanket bans are harder to justify. Bad news because sloppy behavior, online or offline, becomes ammunition. Imagine this scenario. You post something heated, not illegal, but aggressive. Someone files for a restraining order. A judge reviews your words and decides they signal a credible threat. Now pause. This isn't about guilt. This isn't about intent. This is about how your behavior is interpreted under pressure. And under this new framework, that interpretation can temporarily touch your rights. At the same time, if a government official nudges a platform to silence you for that same post, that's a First Amendment problem. Same words, two amendments, two completely different legal outcomes. That's the tightrope we're walking now. This is why lazy takes online are dangerous. This is why screaming "rights are dead" helps no one. And this is why understanding what the court didn't say matters more than what it did. Because the real fight isn't over guns or speech. It's over who gets to decide, under what rules, and with what evidence. And in Part 3, I'm going to break this down into real-life do's and don'ts. What protects you, what exposes you, and the one mistake that turns legal gray areas into irreversible consequences. This is where everything becomes real. Not theory, not headlines. Real decisions you might make on a random Tuesday that echo for years. Because after this Supreme Court moment, the most dangerous thing you can do isn't owning a gun or posting online, it's assuming the rules are simple. They aren't. So let's get practical. Here's what this decision means for you if you live under gun laws in the USA. First, process is king. Rights don't usually disappear in one dramatic swing. They erode through steps, findings, orders, technicalities. That's why courts keep repeating the same words: specific, limited, temporary. If a judge hasn't made a clear, documented finding that someone is a credible physical threat, this 8-to-1 ruling does not apply. Period. That safeguard matters. And if it's missing, the government's case gets weak. Fast. Second, duration matters. The court didn't bless permanent disarmament. They allowed temporary restrictions tied directly to active court orders. Once the order ends, the justification ends with it. That time limit is not optional. It's constitutional oxygen. Third, and this is where people get themselves into trouble, your words create context. Online posts, text messages, DMs, comments, not because speech is illegal, but because speech is evidence. A heated post might feel harmless in the moment, but in a courtroom, stripped of tone and timing, it becomes a puzzle piece. And judges don't see memes. They see patterns. This is not about self-censorship. It's about self-awareness. Now flip to the First Amendment side. If a platform deletes your content because of its own rules, that's private action. But if government officials apply pressure, explicit or implied, that's different. The Supreme Court made it clear. The government doesn't get to outsource censorship and pretend its hands are clean. That line protects gun educators. It protects activists. It protects unpopular viewpoints. But only if people understand it well enough to challenge abuse when it happens. And here's the final twist, the one nobody tells you. These rulings don't shrink rights. They define the battleground. They force clarity. They force accountability. They force courts to explain why and how far every restriction goes. And that's powerful, if you know how to use it. The real danger isn't the decision itself. It's the myth machine built around it. Because myths make people reckless. Recklessness creates cases, and cases shape the law. So, if you care about gun laws in the USA, if you care about speech, if you care about staying on the right side of both, don't react. Understand, because rights aren't lost overnight. They're lost when people stop paying attention.